Okay, and
I
why is
can't
that?
see myself on the screen.
Are you under the influence of anything at this time?
No, ma'am. Oh,
You know what,
one more
Mr.
other
Edwards, you
thing,
need to
ma'am.
appear in person. You need to appear in person today, okay?
How was I supposed to appear in person? I live in East Point, Michigan. That's down there by Detroit.
Okay,
I
well, you
don't
need
know
to do
what's
that
going
in the
on, ma'am,
courtroom,
and
okay?
I understand this Zoom is illegal according to Tyler versus Illinois.
Welcome to Sovereign Citizen Legal Encounters. All right, today we're going to be in court with a sovereign citizen that may be a little bit intoxicated, but also he's talking all of that language from what you saw in the snippet. Also, I got something real good for you today, okay, to make you laugh. So I hope you go check it out. When this video is about done, I'll stick it in there somewhere for you. And I want you to let me know how you like it, okay? Let's go.
On the record in the matter of the people of the state of Michigan versus Gennaro Edwards, file number 23-00747, counsel appearance.
Brian Ring on behalf of the people.
I had somebody represent me.
I'm sorry?
I didn't understand how somebody represent me and I'm representing myself.
No
And
one
I
has,
can't see
no one
myself
said that they were
on Zoom.
Nobody said they were representing you.
Oh, I thought that's
He
what
said,
you just.
he said
I
he was here on behalf of the people.
Oh, okay, my fault. I'm sorry, Your Honor.
Okay. You wish to represent yourself, sir?
Yes, ma'am.
Okay, and why
I can't
is that?
see myself on the screen.
Okay. Are you under the influence of anything at this time?
No, ma'am.
He do have a little bit of slurred speech.
Okay. I don't know why you can't see yourself on the screen.
I could just hear me and see you.
Okay.
But that's okay.
That's
okay.
okay. Okay. So you understand, sir, that you do have the right to have court-appointed counsel represented at the expense of the public if you cannot afford to hire an attorney?
Yeah. Yes.
Okay. And you wish to waive that, you say?
Yes, ma'am. Oh,
you know what,
one more
Mr.
other
Edwards,
thing,
you need to appear in
ma'am.
person. You need to appear in person today, okay?
How was I supposed to appear in person? I live in East Point, Michigan. That's down there by Detroit. I've been served a summons felony and not a complaint felony. I don't know what's going on, ma'am, and I want to avert the jurisdiction and read my warranto into record.
Huh?
Okay.
I don't know what's going on,
in
ma'am,
okay?
and I understand this Zoom is illegal according to Tyler versus Illinois.
Tyler versus Illinois was a U.S. Supreme Court case decided in 1977. The main issue was whether the defendant's Sixth Amendment right to confront witnesses was violated when the prosecution introduced prior testimony from a witness who was not available for trial. The court ultimately held that the prior testimony was admissible because the defendant had an opportunity to cross-examine the witness during the earlier proceeding. The decision reinforced the idea that prior testimony can be used if the defendant had a fair chance to challenge it initially. In other words, that case is not valid.
48 for US 400. I know it is. So I know I have to report, but you're going to have to give me some time because I don't have transportation.
Okay, when are you gonna get here?
You're going to have to at least give me a month.
Oh, no, he didn't.
You're going to have to leave.
No, you're not getting a month. You got a court date on the 13th.
I can't make it. I can't make it.
Okay, well, then you'll get a warrant, okay?
I'm asking the court
if you don't appear on the 13th, you'll have a warrant for your arrest. We're not giving you a month to show up to court.
Ma'am, I'm asking the court
Do you have any questions at this time?
Yes.
What's your question, sir? I'm happy to answer them, but what I won't do is go back and forth with you about nonsense, okay?
Okay, yes. All right. I have a courtroom warranto. May I read it into record?
I'm sorry, you have what?
I have a courtroom warranto. It's QUO, warranto, and I have lack of jurisdiction and a motion to
Oh,
dismiss.
okay, gotcha. Yeah, you need to file that with the court and serve it on the prosecutor. We're not reading that on the record today, okay?
We can't read it. All right. Well, since
No,
we
you need
can't
to
read it
file
on
it
the
with the
record,
court. You need to do an appropriate filing, and then you serve the prosecutor, okay?
I will, ma'am. But I have one more other thing. Since this is probable cause, can you at least let me know what my charges is and who is lodging the charges against me?
Yeah, did you appear for your arraignment on March 8th?
Yes, I did, ma'am. And they put
Okay,
me on a
okay, and weren't
personal
you advised
bond.
at the time of what you were being charged with?
She said something about larceny, but she didn't say from who.
It's exactly what you're being charged with, larceny.
Yeah, right, but she didn't say from who.
You're being charged by the people of the state of Michigan for count one on or about August 19, 2022 through August 20th, 2022 at the area of 4600 Collins Road, City of Lansing, Ingham County, State of Michigan, for allegedly committing the act in count one of larceny, $1,000 or more, but less than $20,000. It alleges that you did commit the offense of larceny by stealing money that belonged to a Avonshire. The value of the property stolen $1,000 or more, but less than $20,000. This was contrary to Michigan Compile Law 750.356(3)(a). That's a felony. Maximum penalty 5 years and or $10,000 in fines, or 3 times the value of the stolen property, whichever is greater. To impose a fine of 3 times the value, the defendant must admit the amount, or it must be determined by a trier of fact at trial. There's an habitual offender, 4th offense notice. So that would enhance the maximum penalty on this. It says take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about May 11, 2016, he was convicted of the offense of failure to return rented property, $1,000 to $20,000, in violation of MCL 750.36583A in the 16th Circuit Court of Macomb County. And that on or about March 7th, 1997, he was convicted of the offense of delivering, manufacturing less than 50 grams in violation of MCL 333.74012A4 in the 4th Circuit Court of Jackson County. And that on or about March 7th, 1997, he was convicted of the offense of carrying a concealed weapon in violation of MCL 750.224 in the 4th Circuit Court of Jackson County. And that on or about March 7th, 1997, he was convicted of the offense of felon in possession in violation of MCL 750.224F in the 4th Circuit Court of Jackson County. And that on or about February 5th, 1993, he was convicted of delivering, manufacturing less than 50 grams in violation of MCL 333.7401224A in the 31st Circuit Court of St. Clair County. And that on or about March 14th, 1991, he was convicted of the offense of delivering, manufacturing less than 50 grams in violation of MCL 333.7401224A in the 4th Circuit of Jackson County. And that on or about August 5th, 1991, he was convicted of the offense of delivering, manufacturing less than 50 grams and contrary to MCL 333.7401224A in the 31st Circuit Court, St. Clair. And that therefore the penalties are a maximum of life if the primary offense was 5 years or more, or 15 years or less if the primary offense has a penalty of under 5 years. This is again a larceny with the maximum penalty of 5 years. So you are facing life as a maximum penalty. I ask you again, do you want court-appointed counsel?
Okay, ma'am. I wanna interject that the MCR 404B1 said you have to show conformity to the habitual, and there's no conformity. And is over
This
10
is a
years
probable
old.
cause conference. We don't have to
It's
show any
over 10 years
conformity at a
old, ma'am.
probable cause conference. So this is what we're gonna do. We're gonna see you in person next week, okay, sir?
I can't make it.
Well, if you don't make it, guess what's gonna happen? A bench warrant will issue. You go ahead and have a good day. I got other cases to handle.
He wanted reading of the charges. Well, he got it. And on top of that, she muted him with the quickness. She said, I'm not hearing it anymore today. A lot of them need to do that. I've been running across those lately. So he has one more hearing. On the next hearing he was supposed to come to, I think he came. Maybe they didn't air it because I was able to find it, but he wasn't there. And it don't show that he had a warrant or anything. Before we get into that last hearing, I got something you need to look at. Might be a little bit important. It's only going to take about 1 minute, and then we're going to go into the next hearing, okay? Let's go. Welcome to Sovereign Trust Bank, where your financial future is our priority. At Sovereign Trust Bank, we believe in empowering you with the knowledge and tools to take control of your finances. Ever wonder why your name is in all caps on every legal document? It's not just a coincidence. That's not you. That's a corporate fiction. It's a legal entity created for administrative purposes. Under UCC 1-308, you have the right to opt out of the system. No contracts, no consent, just freedom. Take control of your identity and your life. At Sovereign Trust Bank, you're not just a customer, you're the beneficiary. Every new member unlocks access to their $1 million trust, set up in your name since birth. App features, yeah, we got it. View your trust, manage your estate, move like a sovereign. This isn't just banking, it's sovereign. I hope y'all enjoyed that commercial, and you know it wasn't real because I'm not supporting no sovereign bank and I'm not putting my money in it. Now, I just had to make y'all laugh for the day, okay, before you go into the next hearing, because I'm sure that smile gonna turn upside down. Okay, let's go.
On the record in the matter of the people of the state of Michigan versus Gennaro Edwards, file number 23-00747. Chairman Taylor.
Jeff Roberts on behalf of the people, Your Honor.
Mr. Edwards, you're representing yourself, correct, sir?
Yes, ma'am.
Today was the date and time set for a preliminary examination. Are we ready to proceed?
Yes, Your Honor. At this time, the people have subpoenaed witnesses. Those witnesses did appear, however, after conversations with those witnesses, I believe the people would be unable to meet their burden at this time, so the people are unable to proceed. I would leave to the.
You're unable to meet your burden, and so what are you going to do?
People would, if the court grants, people would seek to dismiss this case at this time.
Motion to dismiss is granted. You have any questions, sir? I can't hear you.
No, ma'am.
Thank you. We'll get you a copy of the dismissal. You can have a seat.
Thank you.
Hey, I don't know what happened with that, why all of a sudden it was an issue with the witnesses, but Mr. Sovereign Citizen is walking out the door. Maybe he'll be back for something else. Who knows? We'll see. But anyway, thanks for watching. Once again for the fake commercial. I hope it made everyone's day, make y'all laugh. Especially if you're not sovereign citizens, you're gonna find it funny. But if you sovereign, you're gonna hate it. Have a good day, evening, or night. See you around next time.